Mill Forest subdivision, Section 2. It's zoned rural residential. It's tax map number 21-11-0-A-0, and it consists of approximately 0.616 acres. Well, that's less than approximately. The issue on appeal is the county issued, our zoning administrator issued a notice of violation with regard to the violation of a proffer. That proffer was offered and accepted by the Board of Supervisors as part of case rezoning 1999-10. The proffer in question states a minimum of one water impoundment structure complete with a county-approved dry hydrant will be constructed within the proposed development. As you can see from the vicinity map, that's approximately the area we'll be discussing today. Within the Mill Forest subdivision, Section 2, you can see the little red box around the lot that we're talking about. And then there is just the aerial photograph of the lot we're talking about as well. The initial rezoning case was approved in January of 2000, which includes Proffer 10, which I read to you earlier, requiring a water impoundment structure and a county-approved dry hydrant. The county received a complaint earlier this year that a pipe had been recently installed on the property from a Mill Forest resident. The property was designated by the appellant as the location for the water impoundment structure with a dry hydrant to serve Mill Forest Section 2 per Proffer 10's requirements. The property in question is currently owned by the appellant, and it was never conveyed to the HOA. Here is a copy. You've seen many exhibits, but the highlighting there in 10 deals with the water impoundment structure with the dry hydrant. And then there you can see again on the conceptual, on the plat. And then there's a zoomed in version of it as well. Upon receipt of a complaint, county officials investigated the complaint. What they found when they looked at the property, that there was no water impoundment structure on the property at all, nor evidence that one had ever been constructed. The recently installed pipe didn't connect to anything, and there were no records or other evidence of installation of a dry hydrant on the property or evidence of a water impoundment structure. So there's no evidence of county approval, and it was never included in the fire rescue's list of dry hydrants for use in an emergency. And then there are pictures. So after visiting the site, evaluating and searching county records, the zoning administrator issued a notice of violation that the property was not in compliance with Proffer 10 as a water impoundment structure, nor a county-approved dry hydrant had been installed on the site. She determined that Proffer 10 requires the construction of a water impoundment structure, which was never done, and that it also required the construction of a county-approved dry hydrant, which was never done. And she issued an NOV requiring that the appellant installed an approved water impoundment structure that satisfies the requirements of Proffer 10. And this is the notice of violation that's appealed today. I'm happy to answer any questions you may have.
Thank you. Please, Dara.
Mr. Chairman, board members, my name is Darvin Satterwhite. I'm here on behalf of the appellant today, who is Courthouse Associates, LLC. I also have with me the principals for the LLC. Mr. Lee Gordon is here, and Archie Gordon, along with Mike Harris, who are the principal partners there in the LLC. I think the one thing that has really come out of this, out of the briefing process, which is very useful, because I think those things can help to sort of narrow the issues in the case. And that indeed is the case here, because when we look at the notice of violation, the only thing we can determine is that it's not functional, this water impoundment and this dry hydrant. When you look at the notice of violation, it says it's not functional. Our assumption then is that it hasn't been repaired and maintained over the years. That issue has been eliminated. The county concedes in their brief that that is not something that we're here to argue about today, whether it was maintained or repaired over the years. But what we are here to determine, and Ms. Marshall and I think are in agreement on this, is whether or not a water impoundment and dry hydrant was constructed on that 0.6 acres and approved by the county. That's the sole issue. It has nothing to do with what transpired since the time it was actually built. The rezoning on this property in Mill Forest Section 2, Mill Forest 2, Section 2, was actually back in January of the year 2000. You saw the proffer. We have it there. All it says is you are to construct these facilities. I have Mr. Gordon here today who is directly involved with the construction of those facilities. So, and would proffer to you now that his testimony would be he's got experience in constructing these things. He did construct it according to the standards of the industry back at the time this subdivision plat was approved for this particular section of Mill Forest. So I think we can show you without a doubt that it was certainly constructed. Now, I'm hearing the word approved a lot. The county never approved anything with respect to this particular proffer 10 or the water impoundment site or the dry hydrant. And nothing could be further from reality because the county did indeed improve it. Sarah, could I ask you on our PowerPoint if you can just bring up the PowerPoint portion? All right. What you have before you there, and this is actually part of the brief that we filed, one of the exhibits. The county subdivision ordinance, Article 7 of the subdivision ordinance that was in effect at the time this particular water impoundment and dry hydrant was constructed back in prior to the subdivision plat approval back in 2003. And if you look at it, it's different than what you've got today, but we're dealing with the ordinance that was in effect at the time. That's what law that we would apply to this. And we have to have it, this thing, fire protection for dry hydrants have to be at a location approved by the plats officer. Well, we have to look at the subdivision plat, see if that 0.6 acres is on the subdivision plat, and indeed was that subdivision plat approved. And I can tell you right now, yes, it was back in 2003. I don't see how that would be a disputed issue. So the location shouldn't be a problem. I know I've seen some things in the brief, well, we don't like the depth of the water there or whatever. The county approved that site when it approved that subdivision plat back in 2003. And then as you go down into this ordinance, it basically tells us that you have to build one, and it has to be according to county standards. Back then, there were no county standards. You may have them now, but there were no applicable county standards to go by. You built them according to the standards of the industry at the time, and that's what Mr. Gordon is prepared to testify to today, that it was constructed in that manner. Now, we've kind of cut and pasted this ordinance so you can see it on one sheet. So the part that I've put in there that was also an exhibit to our brief that we filed with the county deals with the approval of subdivision plats, what's called Section 3, the bonding requirements for the subdivision plat. And what that says there in that second column is that prior to the filing with the plats officer of a final plat for what? A final plat for approval. All improvements, all of them, not just some of them, but all of them that are required under Article 7 of this article must be completed or the provisions made thereof. In other words, you have to put up a bond or a letter of credit or something like that if you haven't completed them. All right, that is the applicable ordinance that is in effect at that time. So the next question is, well, all right, we see what has to be done. We see that the subdivision plat approval is what indeed marks the fact whether or not they were done and completed and done according to what the county wants by the approval of the subdivision plat. That's a simple question. And if you look, I think the next slide is the subdivision plat. This is the recorded subdivision plat, the face sheet, that actually has all your proffers listed on there and so forth. But there is one box on that sheet of this subdivision plat for Mill Forest 2, Section 2, that is required to be signed by the county, and your subdivision plat cannot be recorded in the clerk's office of the circuit court here in Goochland County unless that approval is indeed in place. And I've highlighted it there. Approved by the county, approved by Goochland County Planning Office, Anita F. Barnes, and the date is September 26, 2003, almost 15 years ago. So if we look at this approval of the subdivision plat, what I've just shown you in that ordinance, once that plat is stamped approved by Goochland County, they have basically said, yep, whatever improvements you needed to do with regard to this subdivision have been done, and we're certifying that effect, and you can put this plat to record by that signature. If I could have the next slide. There it is, approved back in 2003. We're here and prepared to provide you with evidence today from Mr. Gordon again that prior to the time that this subdivision plat was marked and stamped approved by Goochland County, that those facilities were in place and by the stamp on this plat were thereby approved. Otherwise, Goochland County is not following its own ordinances, and I would assume that is not a position that the county would be taking. Again, I'm prepared to submit to you a number of exhibits. They were the same ones principally that were attached to my brief. I do have them if it's the board's pleasure to accept them now or through a witness. I'd be glad to. I do want to get them in at some point in time, but at your pleasure and what you deem to be the appropriate time. But I do have the ordinance that I'm referring to here, and I also have the subdivision plat that is marked approved here as well for submission.
Are you planning on bringing forth those witnesses?
I just have one.
Okay, witness.
Just one.
All right, I guess we can do it at that time.
I'd like to reserve the right to bring Mr. Gordon forward to
Okay.
submit testimony to you. Okay. Thank you very much.
Thank you. Want to hear from the county again?
Well, first things first, I think one thing that's important is to talk about the standards of review for what is before you this afternoon. First, the zoning administrator, Ms. Barnes right here, has the authority to interpret and enforce our zoning ordinance pursuant to state code. Also, her determinations, which you see in the notice of violation, are presumed to be correct. The appellant has the burden, so Courthouse Associates has the burden to show that she is incorrect by a preponderance of the evidence, which means more evidence tending to show they're right than we're right. So with that in mind, I would like to respond to a few things that Mr. Satterwhite presented this evening. The county's case is very simple. We received a complaint. We're a complaint-based for enforcement, so oftentimes things may have been many years before our staff takes a look at them. However, we received a complaint that a pipe had appeared on the spot where the dry hydrant was supposed to be that had not been there before. County staff went out and looked. They inspected. Both the zoning administrator and the fire marshal are here today and prepared to testify and answer any questions you have. Both noted that there was no water impoundment structure. Proffer 10 is very specific. It says water impoundment structure. You'll also notice from the subdivision ordinance that Mr. Satterwhite put up that a lot of those, that it's permissive. The planning officer may require. It also deals with water impoundments, but not water impoundment structures. To date, the appellant has presented no evidence that a water impoundment structure was ever installed on the site at all, other than allegations within his brief. So we have no evidence that there was ever a structure. There are no remnants of a structure out there today. There is merely the pipe, which you can see right here. As to the county approval, approval of a plat is not the same as approving a dry hydrant. That's just common sense. Everything that would be listed would be county approval. Plats do not operate to approve facilities. The purpose of the bonding is to ensure that developers, like Courthouse Associates, construct what they've agreed to construct or what is required pursuant to our code. By not having evidence of bonding from back then, that doesn't mean that the county approved a water impoundment structure and a functional dry hydrant. This is further evidenced by the fact that there is no record of an approved dry hydrant in any county records. Furthermore, this lot has never shown up on the list of dry hydrants that fire rescue would call upon to use in an emergency. So it's not serving a purpose, and in fact, the fact that it's there and not functional is dangerous. Because if you think that you have water somewhere and you're responding to a fire and there's no water there, you could have lost valuable time. So again, I submit to you that there's no evidence that a water impoundment structure was ever completed that's required by the proffer, and I further submit that the county never approved an associated dry hydrant with that structure. I'm happy to answer any questions you may have.
Thank you. Appellant rebuttal?
I think the evidence that we have is going to show you pretty clearly that a water impoundment and dry hydrant was in fact constructed out there. No question about it. So what's the problem? Why isn't it working? Well, I'll tell you why it's not working. Because at 15 years, nobody in that subdivision has bothered to do anything to maintain or improve that pond. Sediment comes in, just like your pond. You might have a pond on your property. Tell you what, if you leave it there long enough and don't do something with the sediment, you're going to have some problems with that as well. But again, we're not here today to argue about who is supposed to repair and maintain that water impoundment and dry hydrant. The county's conceded that's not an issue. They've taken a flat position. It never was constructed. And my goodness, I don't know. We get into all this legalese sometimes, I know, between we lawyers, but this ordinance could not be any clearer. It's just in plain English, and it basically says that an accessible dry fire hydrant shall, not maybe, but shall be required in subdivisions that contain water impoundments according to the requirements of this section. And couple that with the fact that we do have a proffer number 10, the one we're here to talk about today, that when the county accepted that proffer by law, it became part of the ordinances of Goochland County, and it says you shall construct. Okay? We agree, we shall construct, and we did. But to say that the approval of that subdivision, which is an improvement, who can deny that a water impoundment and a dry hydrant is not an improvement that's part of what's required in your development, particularly when we, as the developer, puts a proffer in saying we're going to do it. It is required. And then you come to the subdivision plat approval part of the Goochland County ordinance that basically says you got to have all these improvements done and completed before we'll stamp your plat. Well, guess what? They did. I just showed you. They stamped their plat. Now, they may not like it today that sedimentation over 15 years has drained into that, and nobody's bothered to go out there and fix it. And true, it may not be functional today because of those reasons. That's not what we're here to decide today. We're to decide, did we construct it? And we did construct it. And I'm going to show you that through Mr. Gordon. And I've already showed you that the county approved that construction when it improved all the improvements within that subdivision when they signed off on that subdivision plat. So says their own ordinance. But again, we would reserve the right to give you some testimony on that.
Thank you. County rebuttal at this time?
Chairman,
Yes.
if he wants to present the witnesses.
Just do, okay.
Ask him now.
If I may reserve my rebuttal.
Yes. Apologies to everybody, first time sharing this. So if now is the time for you to present witnesses, please do. Witnesses.
Is there anywhere?
Oh, then just,
Please come to the podium.
yeah, just come to the podium.
Yeah.
I'm
And
gonna,
and he will have an oath for the witness.
I'm gonna kind of say
That's
it
fine.
here, if it's all right, we'll just.
That's fine.
Let Mr. Gordon come up, 'cause probably, he'll probably be doing more talking than I will.
You can-
Mr. Gordon, would you come forward?
I'm a little hard of hearing too, so I apologize.
Yeah, I do, and we should do that right now. Mr. Gordon, I have an oath for you to take or answer. Do you affirm that the testimony you give before us today shall be the truth to the best of your knowledge?
Absolutely.
Thank you. I think you all have the floor.
Gordon, state your name and address for the BZA, please.
Lee Gordon. I live at 1820 Rockcastle Road in Goochland, Virginia.
All right, what is your occupation, sir?
I'm a contractor and developer.
And how long have you been in that occupation as a contractor and developer?
Well over 30 years.
And are you involved in any way with the LLC Courthouse Associates, that is the appellate in this case today?
Yes, I am. I'm one of the members.
And were you involved with the rezoning of Mill Forest 2, Section 2?
Yes, I was.
All right, and how actively were you involved with that?
Very active.
And with regard to the submission of the proper number 10 that we've seen on the screen today, were you involved with the submission of that particular property?
Yes, I was.
And were you involved in the subdivision approval process for this section of Mill Forest?
Yes, I was.
How actively involved were you?
Very active. Intimately active.
All right, now we've got the discussion regarding what the county's referred to and what I've referred to as the water impoundment facility or water impoundment structure with a complementing dry hydrant. Were you involved at all with regard to the construction of the impoundment and the dry hydrant?
Yes, I was.
And how actively involved were you?
Very active.
Now, do you know whether or not they were completed?
Absolutely.
All right, describe that to the board.
Well, and I don't know if you've got the thumb drive or pictures and so forth. I don't know if you want to look at that at all, Darvin, but
If we could.
I know there was a little question about, or there is a question about whether it was installed or not. And I can absolutely 100% say emphatically that yes, a water impoundment facility was built, it was installed, and a dry hydrant was installed as well.
And
Now-
Mr. Gordon, you've heard me indicate to the board that this particular subdivision plat for this section of Mill Forest was approved by the county in September of 2003.
Yes.
Can you tell this board whether or not you had in fact completed that water impoundment structure and dry hydrant before that plat was approved?
It was built prior to that. It was probably closer to almost 18 years ago. Well before 2003.
That these two facilities?
The two facilities were installed.
All
Yep.
right, and when I refer to two facilities, I'm referring to collectively, really, as both of them, the water impoundment facility and
Yes.
and the dry hydrant.
And the dry hydrant, yes.
All right. Now, there's a photograph on the screen that we have here before you, and I'll submit these in printed form to you as well. I don't have them now, but I have this. This particular photograph, when was it taken?
About 3 hours ago.
And what does it depict?
The pull-off area, the parking area that's required so fire trucks can pull off the main hardtop road into a area that they can hook up to the dry hydrant.
And who took this photograph?
I did.
If we could have the next photograph. All right, now what do we have there? What are we looking at in this particular photograph?
We're looking at the standpipe that comes up that helps supply water from the water impoundment facility so that the fire truck can hook up to the end of that pipe.
All right, we could have the next photograph. What is that? What are we looking at?
We're looking at where the pond was, and there is riprap lined. I've got some other pictures to show where the whole area was lined with riprap when it was originally installed and built.
And that was part of, all of what you're talking about here, let me just clarify, is this what you're talking about prior to the subdivision plat approval?
Yes.
Okay. What is this here?
That's just another picture of additional riprap that was placed to protect the banks and so forth for the water impoundment facility.
Right, and what's the, if we could have the next photograph?
That's a picture of the pipe that goes through that shows water that is there currently in the creek in the little the area where the water impoundment facility was located.
All right, let me ask you something about that subdivision plat. Chairman, these are just a little larger copies of the very same plats we've been looking at.
Excuse me.
More helpful if you could look at these. We've got the area marked and we refer to those.
Okay.
Exhibit 1.
While you're looking at that, I believe the clerk for the board has marked that as Exhibit 1. I've already referred to, so we don't get it lost in the mix, so to speak, that existing, the ordinance that was in place back in 2003 when the subdivision plat was submitted. I did not cut and paste this. This is the same one that we had with their brief that was submitted to the county. So if we could have that marked and introduced as 2
Okay.
marking.
Exhibit 2 coming?
It was submitted with the brief.
This was, yeah.
All right, then it's already part of the record, and I think that's adequate.
As long as it's included as part of the.
Right, but the handout today would be a new exhibit, so
It is, and I will just for clarification purposes, state that what was on the screen that I showed was simply a condensed.
were excerpts from the prior ordinance
Right.
attached to your brief.
Yes, sir.
We're clear on that. Thank you.
All right, Mr. Gordon, let me show to you what I just handed to board members and the clerk. That's what I've represented to the board as being the Mill Forest 2, Section 2 approval sheet, initial sheet of the subdivision plat that's recorded in the Goochland Circuit Court. I see up here in the upper left-hand corner an instrument number. Do you recognize that?
Yes.
And that's where it's recorded in the
Yes.
clerk's office. All right, let me direct your attention to the second page of what we have on this exhibit, which appears to be the plat itself. All right, do you see the yellow highlighted portion there?
Yes.
I think Ms. Marshall represented to the commission that there is an area of .616 open space on which the facilities are to be constructed.
Yes.
And is that the area that they're supposed to be?
Yes.
All right, and I see what appears to be a creek or a dotted line. I take to be a creek. Is that what you're
Yeah, a
understanding?
small stream, yes. Mm-hmm.
We'd like to, I know it's been marked as long as it's been introduced.
So noted.
And it's your testimony here today that what you've shown in these pictures, being the pictures that were taken today, show the water impoundment facility and the construction work for the dry hydrant that was done prior to this plat being approved?
Yes.
Is there another photograph?
Mhm.
All right, I know that's awful dark, but there's a reason that that's dark. Can you explain to the board what we're looking at here and why that?
Just also for additional clarification, coming here to reiterate the fact that this was built, it was installed. We cut the top of the pipe off, we removed it. I took a picture looking down in that pipe. That water level is approximately 7 feet below the top of the pipe. That's what that represents right there. You're looking down a 6-inch pipe. Not very clear, but you can see that there's water at the bottom of it.
But you're testifying under oath here today, under penalty of perjury, that is looking down that pipe that you installed prior to the approval of this subdivision plat in 2003.
Yes,
And that was in place at the time.
yes, about 3 hours ago that picture was taken.
And the construction work was done before this plat was
Yes.
approved. Next photo. What is this here?
This shows the depth of the pipe. The way that this is constructed, there's a transition that goes from where the fire truck would hook up. It's a standard type of a fitting that all fire trucks hook to. It goes over, it's supported by a post. It transitions, makes a 45-degree turn. It goes straight down. It goes down a little over 11 feet, and it makes a turn and goes out into the water impoundment facility area. And there's a strainer on the end of that. And that strainer's got like a flapper valve on it. So that way when the fire trucks come in there and they hook up to that, they backwash it. So they blow any kind of silt, any kind of debris and so forth away from that pipe, so that when they're able to retrieve water, it retrieves clean water.
All right, could you have the next photo?
And that's just another picture of basically the same thing. It's standing away from it a little further to show you how far the pipe is off the ground. From, you know, it's not like I went up on a ladder and dropped the pipe. No, this is cut at almost at ground level. So you go down 11 feet, and that's where that pipe turns.
And what do we have here? I believe this is the final photograph.
Yes, that shows the edge of the pavement of the existing road that transition, and it goes by where the pull-off area is. And that shows that the sufficient area that you can pull a fire truck or anything else in there that you wanted. I had 2 trucks in there this morning, about 3 hours ago.
And that was in place and constructed as you've indicated these other things in the photographs that you've shown?
Yes,
Prior to the time that subdivision plan was approved?
yes.
I didn't know how you wanted, I mean, I've actually got them on here, if you wanted to submit them that way.
I think you should, if you want them in the record.
I just want these in the record.
Yes.
I certainly don't mind the county printing these, but I'm not, with it being electronic, I didn't know which way you went.
I think that's fine, just give the disc to her,
Okay.
to Ms. Worley. I guess you can mark the photos as Exhibit 2.
And we have the ordinance, I think, you said it's all.
Yeah.
Okay. Just want to make sure I wasn't missing.
Yeah, no, that's part of the brief.
Now, at the time you completed the construction work prior to the subdivision plat being approved back in 2003, did the county make any complaints to you regarding the nature of the work that you had done out there on that water impoundment and on the dry hydrant?
No,
And did they offer you any particular standards at the time, saying you need to do this, that, or the other with
No.
regard to the construction?
no.
And have you constructed facilities like this in the past as part of your work as a developer of subdivisions?
Yes. I put one in different subdivisions, a couple. I put in residential applications and in a commercial application.
I'd like to ask you this, and just for clarification purposes. You said you're a developer and you've been developing for a number of years now. How much of that work is here in Goochland County?
Probably about 80%, most of it.
Now, from your background and experience as a developer, having worked in these water impoundment facilities and constructing them in your in the dry hydrants, Do you have an opinion as to whether or not this was constructed within the standards of the industry as they existed back in 2003?
I do have an opinion, and I say yes, it was installed to standards.
And you got no complaints about the construction with regard to
No.
those standards? Just for a second, maybe shorten this. The time that those facilities were constructed back in 2003, did the county make any complaint with regard to where you were constructing?
No.
And they were shown on that plat that I put into evidence today,
Yes.
and that plat was.
Yes.
The notice of violation that you received, and I'm paraphrasing here, but basically states that the facilities were not functional. In your opinion, were they functional back in 2003 prior to the time that plat was approved?
Yes.
Do you have an opinion as to why they're not functional today?
Absolutely.
Well, explain that to me.
It has, over a period of almost 18 years or thereabout, constant sediment has silted into the sediment basin. There's been no cutting back of bushes. There's been no maintenance whatsoever done to it. So over a period of many years, it has silted in, and it's kind of just filled up the water impoundment area.
Is it fair to say that that is a maintenance and repair type
Absolutely.
feature?
Yes.
I don't have any further questions.
Jeff?
Yes, I'd like to ask
Yeah,
a question.
go ahead.
Mr. Gordon, if I could, please.
Please.
You mentioned that you felt that the reason that it wasn't functional today was primarily because of the sediment and silt that had built it up over 15-plus years.
Yes.
If the sediment and the silt were appropriately addressed, would the system work today?
Yes.
Mr. Gordon, do you still own the property?
Yes.
You are still and was there a reason why it wasn't turned over to the HOA at any point in time, or why, after 18 years, do you still why do you still have it?
We probably have several pieces of properties and different right-of-ways and so forth. And so that is something that we need to do, and we have been in the process of doing that, but that piece was never conveyed. And there was not just that piece, there are other pieces as well, not just in that subdivision, but others also. So yes, that is something that needs to be done.
Yes.
How is the homeowners association notified that they are now responsible for maintenance?
There was of course, originally the covenants was recorded, and in that it's structured language and so forth that at such time that we would put in a dry hydrant and water impoundment facility, that they would take and assume any rights, duties, obligations, and so forth when a homeowners association was created. And so a homeowners association was created many years ago.
And that's in the documents?
Pardon?
That language is in the documents?
Yes.
Since you've obviously done this before, who would you have expected from the county to go out there and
Who would I
inspect it?
expect to go out there?
Yes, I was just curious. Or do you think anybody at the county at that time maybe did at least see it?
I would have
Just-
think, now that prior to
Back,
2003,
back in that day,
so we
yes.
have two different time frames that I'm looking at.
Mhm.
In 2003, I would assume that somebody from either the administration, some area, or possibly fire and rescue, or they would go out jointly to inspect it and look at it. And then as of today, there again, I would think that primarily probably fire and rescue should look at it because they're probably more qualified to determine whether it's capable of working properly and so forth.
In doing others like that back in that time period, did you ever receive anything that was a kind of a formal, passing inspection, so to speak, for the dry hydrant more than you got in this one.
Right, no.
Included in our packet was a correspondence between one of the homeowners in Milford. Am I loud enough? Sorry, I don't want to be yelling in.
Like I said, I'm a little hard of hearing, I apologize.
No, that's fine. Between one of the residents in Mill Forest and one of the Board of Supervisors saying that all of a sudden a pipe showed up.
Mm-hmm.
Why did the pipe just show up? Like, what was the point of that after so many years of it just not being there? Why, I guess?
The pipe was removed approximately, and I can't remember exactly, but some years ago, a couple years ago, something like that. And it was mainly also for the protection of the neighborhood, just like that was brought up here a little earlier, is that if a fire truck came down there and tried to hook up to that thing, all they would do is suck in silt. That's all they would do. So that's why it was removed. Originally, 2 years ago, whatever it was, something like that. And then it was put back on there because the position was it was never installed in the first place. And yes, it was installed. The whole system was installed.
Thank you.
I want to switch gears if I could just a second. Ms. Marshall, I think you mentioned that the fire marshal who did the inspection was here today.
Yes, sir. He did.
Could we ask a question or two of him, please?
Mr. Doug Davies is our fire marshal.
I guess y'all are probably good for right now, I think.
Have you-
Questions? Thank you very much. Is that?
Are you
Did you have?
let me just clarify, Mr. Satterwhite, you're done with your case in chief?
Case in chief, of course, we may have some rebuttal depending upon what.
Yes, you'll have your time for rebuttal.
Good afternoon.
Good afternoon, sir. Thank you. Got the oath for you also.
Okay.
Do you affirm that the testimony you give before us today shall be the truth to the best of your knowledge?
I do.
Thank you, sir.
My question is in regards to the inspection that you completed in March of this year, I believe.
Yes, sir.
We just heard Mr. Gordon say that it was his opinion that over the 15-year period of time, there was a significant amount of silt and sediment that have built up in the water source, and that was the reason that the system was not presently functional. Would you agree or disagree with that statement, and could you perhaps elaborate a little bit for us?
I'm not saying that I'm not expert on creeks and ponds and waters and how all that occurs. Only thing I can say is when I went out there, there was only a few inches of water in a very small stream, and I saw a dry hydrant. I saw nothing in the water that would indicate any type of strainer in the water system, and a very inadequate water system. And the dry hydrant itself had a 4x4 post that it was bolted to steady it in the ground. And if that post I could move it back and forth, and if that post wasn't there, I would have been able to pick the dry hydrant up out the ground. So the post was trying to keep it steady, but I saw no evidence of a strainer in the water. And like I said, it was a very small water source, so it was inadequate. As far as what was there years ago, I have no clue. I wasn't familiar with it then, so I don't know if that was the existing water source then or if something had changed over the years. That I couldn't tell you.
Based on your experience in these matters before, had there been a sufficient water source the day that you were there, and had there been some sort of filter, would the system have functioned
It
properly?
should have functioned if there was a proper water source, and if it was installed, to the standard, to NFPA standards, and if it was installed correctly, and it had a proper strainer in the water with enough depth of water to accommodate it, then it should have worked. But I'm not sure how far the draw was, because where the water was in the creek to the proximity of where the dry hydrant was a pretty long draw. So if there was horizontal pipe under the ground, it extended for a pretty long distance. Now whether there was water closer up at some time that put it closer in, I don't know. I can't attest to that.
Thank you.
Mm-hmm.
Thank you.
You have any ability to cross?
I would object to that.
Yeah, At this time, I think the county needs to present their entire case in chief, so let's give them their full allotment of time.
Unless you want me to cross Mr. Gordon.
Just a point of order. I wasn't objecting to that.
No. Do you have other remarks for the case in chief or other witnesses?
I have other remarks to respond to what was just presented.
All right, and I think our agenda shows that each have like 3 minutes for rebuttal. So if there's no objection, we can move forward to rebuttals.
Could I just confer with my client just briefly?
Sure, take a moment.
Based upon what he's just said, I may have some additional testimony.
I mean, it's up, Chairman, I think it's okay if they have a minute.
Yes, you may.
Be very brief.
May I, if it's new testimony, is it about a new?
No, it would be a response. It would be
Okay.
just what I may not have to do that.
We'll discuss questions of the law, and then we come back out. So I think
And that would come after all the closing comments. That would be next after that. I'll ask the group. Okay.
It should be back.
Okay, I'll ask him.
At this point,
Yeah, see, that's right.
yes. So at this point, closing statement, 5 minutes close.
So she's got that under control over there, Sarah
I
does.
mean, you'll ask Mr. Satterwhite to give his closing statement.
Okay. Yes.
I just very briefly have Mr. Gordon solely in response to what he said, nothing new.
Normally, this is allotted for closing statement, so if there's no objection to him using your 5 minutes that way,
We would like to call the zoning administrator if he's going to call additional witnesses.
I think that's fair if
Oh, no,
both of you have that same opportunity.
No, I don't object to that. I
Okay.
just- And what I have now.
But you have 5 minutes for this closing statement and whatever additional testimony you're going to give.
That's more than fair. Okay. May just call Mr. Gordon back very briefly.
Okay.
Mr. Gordon, I'll remind you, you're still under oath. Answer your questions accordingly.
Okay.
Fire Marshal, I believe you just heard his testimony, is that he could not see the strainer when he went out there in March or early this year. Can you give the board an explanation as to why that would be the case, that he couldn't see the strainer?
Yes, and if you can, I'd like you to move the picture forward if you could, just a little bit. This shows the location of where the pipe is. Go a couple more if you would, sir. Okay. And I didn't get a good picture of it. That's what supplies the water. That's what's currently flowing now. Sometimes it's more, usually it's not a lot less. We've had a pretty dry spell. The pipe, that's why I took a tape measure over there, because that pipe is located about 6 feet, 6 feet off the bank, the water level of the existing bottom of the pipe right now. So that when that pipe sticks up, it's about 5 feet above that level. When I put that tape down in there, it goes to 11 feet. So that's a further depth of about 6 feet than what that water level is. The strainer that was installed in there is completely covered up with silt. And I'll be glad to go over there with an excavator and dig it out.
And that's your explanation as to why someone going out there earlier this year would not observe the...
Absolutely, yeah, you can't see it.
But it was installed back in 2000.
Absolutely. And it's installed relatively close to the creek bed. It's not too awful far away. It's certainly well within guidelines.
Thank you.
Thank you.
Do you have any other remarks for your closing statement?
Would you want me to wait on that until all the evidence is in? I think the county indicated they may have some additional testimony.
we'll do it in that-
And I'd like
we'll
to
do it in
save
that
my
manner.
closing to address that.
We'll do it in that manner. This will be a continuation of testimony.
So this county rebuttal?
Yes, sir. If I may call our zoning administrator, Anita Barnes, to provide
Yes.
testimony.
Do you affirm that the testimony you give before us today shall be the truth to the best of your knowledge?
Yes, I do.
Thank you.
Could you state your name and your position with the county?
Yes, Anita Barnes, I'm zoning administrator for Goochland County.
And part of your job also includes approval of plats.
That is correct.
And I believe Mr. Satterwhite presented a plat that you approved previously.
Yes.
And when you approve plats, does that mean all the improvements that are proffered have been constructed?
No, basically when I approve a subdivision plan, I make sure it meets the zoning requirements of the lots, the widths, that forth. As far as when the letter of credits are bond, that's based on the roads. The only thing I'm approving is the location of those plats. So what I'm approving on that plat is the location of the open space that shows the dry hydrant.
So would the approval of a plat mean that a facility that's been installed is approved as structurally complying with the underlying regulations for those particular structures?
Right. No, I'm not expertise on the dry hydrant. The only thing I'm approving is the actual lot itself that's on.
Thank you. And through the course, before you issued your notice of violation in this matter, you had conversations with Mr. Gordon prior to that. Did you have an opportunity to read the briefs submitted by the appellant?
Yes.
Within those briefs, there were contained allegations that you mentioned that this was a maintenance issue?
No.
And that the water impoundment structure and that the dry hydrant had been appropriately installed previously? Do you recall saying that to Mr. Gordon?
No.
Do you have anything else you'd like to add?
No.
Do y'all have any questions for Ms. Barnes?
Go ahead.
At what
Please.
point is those, or are those improvements approved? Who does approve the dry hydrant?
Basically, it's part of the plan of development. It would show in the plan of development. And when they do their inspections, they check off to make sure those things, like the roads are built, they make sure the roads are built to those state standards that we have. So it's part of the plan of development.
So do you have evidence that that was approved?
I don't know.
Why wouldn't you?
It's usually, if it's something on the dry hydrant, I guess that would be through the fire department, fire rescue to inspect those. It's just, like I said, it's part of the zoning case that's required for the one in water impoundment there on the property or the subdivision.
Just to clarify, when you say I don't know, you meant that you haven't seen.
I haven't seen anything, no. That's been
But is that
approved.
the standard procedure? Is in a subdivision, somebody puts a dry hydrant in and the structure, and some physical person goes out there and looks at it and says it's right?
Today it is, yes.
But not back then?
I don't know. That was in another department, so.
Okay.
Anything else?
When a hydrant is approved, a dry hydrant, is it actually hooked up to water to make sure everything is flowing out greatly in that sort of approval? Or is it just the structure itself looks good, but we never tested pressure or anything like that?
It should be up and running and working correctly.
Okay, so at some point water is
Yes.
supposed to be connected and
Yes.
tested and everything?
Yes.
Okay, okay.
Anything else?
Thank you.
I believe the rest of my comments can be reserved for my rebuttal.
Yes, so what we've done is we basically had two additional periods of testimony, and now we can go into the final closing statements by each side. The attorneys agreed? Okay. So you call Mr. Satterwhite.
Mr. Satterwhite, closing statement.
Thank you, Mr. Chairman. You know, the county's put on their witness, first fire marshal, saying, well, you know, one of the principal problems you got out there is it's not a water source. You know, nothing's rebutted now with regard to whether we constructed it or not. Nothing to rebut anything that Mr. Gordon has said. Not one iota of evidence is before you that what he said is wrong. But what evidence you do have from the county tells you, well, you know, the real problem is water source. You need more water out there. The plat approved the site. We started out, we heard this thing to begin with. It's on 0.616 acres. Look on that subdivision plat. That's the site the county approved. Now, maybe today they wouldn't have approved it like they approved it back in 2003, but in fact, it was constructed. And I'm somewhat amazed to hear that now we are 17 years later getting around to inspecting something that was done in before 2003. I think Mr. Gordon said it would have been a couple of years before that. But and in all due respect, I'm not trying to criticize the zoning administrator. She's got her job to do, and I can appreciate that. But Goochland County has ordinances for a reason. They're in writing for a reason. And we've given you the ordinance that basically says, you know what, developer? And that's what it says. You don't get your subdivision plat, which means you don't get your building permits. You don't do anything until that subdivision plat is approved. And it says specifically, it's not legalese, you don't get that until whatever improvements you're supposed to make are done. And we get the memo 17 years later, duh, it wasn't done. That just doesn't make sense. There is no common sense to that. With regard to whether or not we've met our burden of preponderance of the evidence, we don't have anything. You don't have anything before you today that contradicts one thing that Mr. Gordon has testified to. One thing we've showed you on those pictures. Well, fire marshal, I couldn't see the strainer. Okay, we know why you can't see it. It's all covered up with silt. He admits, look, I wasn't out there I'm not an expert on these things. I wasn't out there in 2003. I couldn't tell you what was there then. And you don't have any evidence whatsoever to contradict one thing that Mr. Gordon has presented to you. You do have the passage of time, which I think in a common sense mode would tell you, look, if this thing weren't approved and they didn't catch it at subdivision plat review, what does that tell you that 17 years has gone by? They were perfectly satisfied with it back then. Now, I think the ordinance is clear that subdivision plat was an approval, but the passage of time and just common sense tells you that the county approved it. We don't get to things 17 years later. That would be absurd. So that would be my comments to you. I'd be happy to answer any questions you've got if it's any issues with regard to the factual basis of what was presented to you today. Thank you.
Thank you.
All right, good afternoon. As Mr. Satterwhite stated, the ordinance is very simple, and proffers, when they're adopted, become part of the zoning ordinance. The ordinance that's in question before you today requires the installation of a water impoundment structure with a county-approved dry hydrant. A bunch of rocks around saying that's a water impoundment structure. We have seen no evidence of an actual structure that was installed. We've seen no evidence that one was installed back 17 years ago. What we do have are the covenants, which were recorded in 2003, that talk prospectively about a dry hydrant to be installed, which is not the same as having one installed. We have the appellant who has held on to the parcel of property and not turned it over, nor notified the homeowners association that they have some responsibility for an existing facility. Further, we have modifications to that facility as admitted by the appellant's representative that he chopped off part of the pipe and then put it back, but still did not notify the HOA who is allegedly in charge of maintenance. We put before you that no county approval was ever sought or received for a water impoundment structure or the dry hydrant. In fact, I don't know if the dry hydrant is currently not connected to anything, has not worked, and was not properly constructed or approved. Furthermore, there's a lot of reference to the subdivision ordinance that talks about, it doesn't talk about water, it talks about water impoundments of a ½ acre or more. The parcel's barely a ½ acre, so I'm not sure how that subdivision ordinance that he keeps quoting applies. And essentially, our case is that there is no water impoundment structure. It was never submitted. When you're building something and you need approval for something, you call the regulating agency to come out and look at the structure and give you approval. There's been no testimony that that occurred, and we see no evidence, and we think that by preponderance of the evidence, they have not overcome their burden. I'm happy to answer any questions you may have.
Just a point of clarification, if I could. Did I just hear you say, Ms. Marshall, that you don't have any evidence that the water impoundment facility or the dry hydrant was turned over to the homeowners association?
No, sir. We have no evidence that one was ever fully operational, installed correctly, or submitted to the county for approval.
I have a question. Is there like a approval that we have that should have occurred, like a piece of paper that you would have from other approved dry hydrants from like 2000 and 2003? I mean, is there like a missing document in the file, so to speak?
Well, the proffer itself is its own special ordinance, and that requires county approval. I'm not sure what happened routinely with other dry hydrants as they were installed or what those requirements are. I can tell you that this proffer requires county approval. So, and it doesn't just say water impoundments. If you look at the subdivision ordinance that Mr. Satterwhite has provided you, it says water impoundments. You'll notice that the proffer specifically says a water impoundment structure. You'll also notice that the subdivision ordinance that Mr. Satterwhite talks about ½ an acre. You can see on the plat that was recorded, it's a stream. Therefore, a structure was required.
Okay, thank you. So there wasn't like a form that he should have filled out? It's a
not to my
phone call
knowledge.
to the county
No,
at
sir.
that time. Okay. Thank you. Do we have any questions for anybody this time? Anything? Would y'all guess?
I'm not sure I quite know what a proper water impoundment structure looks like compared to the pictures that we saw. I don't. Is there any way for us to look at what a good one looks like compared to what we just saw, or?
I apologize, I don't have one.
I don't know. I'm not an expert on.
It's my understanding they're often tanks.
Okay. Okay.
I'll just piggyback on that question, and I'm certainly not an expert in any of that, but I feel like when they're putting in roads and stuff, there's normally some sort of engineer drawings that go along with it. Would there have been such in 2000, 2003 because this is right there by the road and would almost seem to have been included in the drawing?
I can't attest to what the requirements would be. I can only say that there's no evidence that any such drawings or requests for approval or anything with regard to a water impoundment structure or dry hydrant on this property was submitted.
Any other questions from the board? Anybody? Would y'all like to enter into a closed session?
Yeah, I'd like to make a motion, if I could, Ms. Secretary, that under the provisions of sections 22-3711 and section 22-3712 in the codes of Virginia, I move that the Goochland Board of Zoning Appeals convene in a short, closed meeting to seek advice from council.
Anybody have a second?
I'll second.
Okay. All in favor of the motion to go into closed session? Aye.
All ayes, motion passes.
All right, we'll move to the
Okay.
room attached here, next door, adjacent, for closed session, and then we'll return here
Briefly.
shortly.
Yeah.
So everyone can wait here. We'll be back.
go back 15-plus years. And as a board, we heard some things today that were slightly different than some of the materials that we received from both sides. For my part, Mr. Gordon, we found you very credible. We found you very believable. And I have no doubt in my mind that something was constructed on that site in the early 2000s. Ms. Marshall, we found you equally credible, and the information that you provided was also very helpful for us. And also a thanks to the fire marshal for his questions, or his answers to our questions, and the inspection that he performed in March of this year. For me, the burden of proof, according to law, rests with the appellant to demonstrate that our zoning administrator's decision was incorrect, and from my perspective, that burden of proof has not been met. Ms. Barnes made the approval in the early 2000s, and she also gave additional testimony, and I feel comfortable that that burden of proof by the appellant, that decision that was rendered in May was a correct decision.
Thank you.
Well, I feel a little differently. The thing that did it for me, I understand that the burden of proof is on the appellant. The pictures with the riprap and the pipe tell me there was something there. Where it went, what happened to it over 17 years, we all know what happened to it. It just silted in. There's no seemed to be no rules or regulations from the county as guidance for what they were supposed to put in. So I feel like that they did put something in and that they did prove their case.
Yep.
I would also agree with that, especially with the photos that I saw, that something was there. Again, if you put anything in the, build anything and then don't do anything for 17 years, there's going to be erosion, and things aren't going to look the way they did 17 years ago, or 15 years ago, I'm sorry. But there was something there. Whether it's up to code now, that's not our, that's not our decision. But I do feel that there was something put there, and then it was approved. And again, that's why we're here, is to say whether or not it was there. And from what I saw today and from the testimony that we heard, that I do think something was there.
Thank you. Yes, I too feel like from the testimony we heard and what we saw, and having been familiar with the location and the site, that clearly something was put in there with that intention. The road is there for a fire truck, and the dry hydrant certainly was not installed recently, and I really don't see any true standards that it was to be held to. And even if that was the case, time and erosion and trees growing have certainly changed the site. But from the photos and just I do believe it was there, and kind of lacking any other more official county approval for any other dry hydrants. This would be the only approval avenue that I would be aware of, and it would appear to have been approved, or if not, so I do feel like it was there, and my thoughts. Yes.
I'm just asking if you wish to clarify your comment about the approval with the plat. That's up to you.
Yeah, I guess I personally see the signed plat approval as being approval of the proffers, unless there are, there are sometimes unfinished properties unless they are bonded, which this was not, with no money set aside to see its completion, which I take to mean it was completed at the time.
Again, I don't think any of us are saying it's a good water structure, or if it's, I don't know if it would handle anything today. But there was something there, and by the signing of this, it seemed to me personally that the proffers were met. So.
Would anyone care to make a motion?
I'll make a motion to rule in favor of the appellant.
Second?
I'll second.
All in favor?
Aye.
All opposed?
I oppose.
Do you have each individual's vote, Sarah?
I have Coe,
Yes.
aye. Parker, aye. Kowalski, aye. And Springman, nay.
All right.
Motion passes.
To move on to the next item on your agenda.
Okay. Next item on the agenda, what do we have?
Oh, we gotta approve the minutes.
I have no other business for you gentlemen and ladies this evening, but we do have the approval of the minutes.
I make a motion that we approve the minutes as written.
Do we have a second?
I second that.
All in favor?
Aye.
Aye. All opposed?
Thank you.
I guess you can adjourn if you wish.
We are adjourned. Thank you.
Thank you.
Well, like I said, it's not really outcome.